I'm Himanshi, and today I'll be discussing the landmark judgment delivered in the case of Messrs. Patil Automation Pvt Limited and others versus Rakheja Engineers Pvt Limited. This judgment was delivered by the Hon'ble Supreme Court on 17th of August 2022, comprising the two judges bench of Honorable Mr. Justice K.M. Joseph and Honorable Mr. Justice Hrishikesh Roy. This judgment settled the conflicting position of law on the issue of rejection of plaint due to violation of the mandate of Section 12A of the Commercial Courts Act 2015. Before we start discussing this judgment, let me first give a brief introduction on Commercial Courts Act 2015. The Commercial Courts Act was enacted in the year 2015. It creates a setup of commercial courts within the existing civil court system and empowers such courts with necessary procedural powers to efficiently and speedily resolve commercial disputes of a specified value. A commercial dispute has been defined in Section 2C of the Act, which contains an exhaustive list of 22 standard commercial transactions that may form the subject of commercial disputes. Let us discuss the purpose of the Act. The purpose of this Act is to ensure that the commercial cases are disposed of expeditiously, fairly, and at reasonable cost to the litigant, and to accelerate economic growth, improve the image of the Indian justice delivery system, and improve the faith of the investor world in the legal culture of the nation. The Commercial Courts Act was passed on 31st of December 2015. It came into force with retrospective effect from 23rd of October 2015. However, the same was amended in the year 2018 that inserted Chapter 3A, which provides for Pre-Institution Mediation and Settlement, making it mandatory for a party filing a suit under the Act to exhaust the remedy of mediation prior to instituting the suit. This is a very significant step that aims at the settlement of disputes between the parties before a suit is filed. This is a mandatory provision which is applicable upon suits after 3rd May 2018. However, an exception to Section 12A can be when an urgent interim relief is sought. For example, Order 39 Rule 1 and 2 and Order 38 Rule 5. In such cases, the requirement of pre-institution mediation and settlement can be dispensed with. Now, what does mediation mean? Mediation is a process which encourages the parties to attempt to resolve their disputes through discussions and negotiations, which are presided over by a third party, namely a mediator. This mediator facilitates and guides the parties to streamline their discussions and mutually arrive at a solution which is beneficial to both parties. Fundamentally, mediation, if successful, actually achieves a complete and final resolution of the dispute rather than a mere adjudication of the rights and obligations of parties. In a civil suit, mediation is generally before the mediation cell. It is the court which sends the parties to the mediation center. But where there is a commercial suit, the plaintiff will have to go for pre-institution mediation and settlement. It is done before the authority constituted under the Legal Services Authorities Act 1987. Say, for example, in Delhi, it can be Delhi Legal Services Authority, which is the DLSA, or Delhi High Court Legal Services Committee. This process of pre-institution mediation and settlement needs to be completed in 3 months. However, it can be extended by 2 months with the consent of the parties. However, this period of pre-institution mediation and settlement can be excluded for the purpose of limitation under the Limitation Act 1963. Now, there can be 3 situations. If the parties arrive at a settlement, it shall be in writing and signed by the parties and the mediator. It shall acquire the status of an arbitral award. If there is no settlement, then a settlement failed report shall be attached by the plaintiff with his plaint. And if the defendant does not turn up during the mediation proceedings, then a non-starter report is attached. Thereafter, the plaintiff can proceed to file a suit. This chapter 3A was added to improve ranking of India in the Ease of Doing Business Index. Earlier, there was a conflict as to what will happen if pre-institution mediation and settlement is not done. So herein there are 2 situations. Firstly, there can be rejection of plaint under Order 7 Rule 11 of the Code of Civil Procedure 1908, which will be a decree, and there can be an appeal against the same. This is a harsh order as the plaintiff will have to bring in a fresh suit after complying with the requirements of Section 12A, and there would be loss of court fees. And the second is that the plaint can be kept in abeyance. Section 12A provides for a mandatory pre-litigation mediation conceived as a measure to provide a speedy and affordable resolution of commercial disputes through the medium of alternate dispute resolution. The purpose behind this provision is to attempt a quick and efficacious settlement through mediation before the dispute was brought before the court. A question always arose whether Section 12 is mandatory or not. Now, this has been settled in the landmark case of Patil Automation Pvt versus Rakheja Engineers Pvt, and this judgment is in effect from 20th August 2022 so that the concerned stakeholders can take the necessary steps. Now, the issues in this case were whether the statutory pre-litigation mediation contemplated under Section 12A of the Commercial Codes Act as amended by 2018 Act is mandatory or not. Second, whether plaint can be rejected under Order 7 Rule 11 of the Code of Civil Procedure 1908, which has been filed without adhering to Section 12A of the Act. Let us move to the facts of the case, which are: the respondent plaintiff filed a commercial suit under Order 37 of the Code of Civil Procedure for recovery of money. The appellant defendant filed application under Order 7 Rule 10 and 11 read with Section 9 and 20 of the Code of Civil Procedure, contending that the suit was filed without adhering to Section 12A of the Act. Now, the trial court rejected the contention of the appellant, holding that the procedure provided under Section 12A is not a penal enactment for punishment, and there is no embargo in filing the suit without exhausting the remedy of mediation, especially when an attempt is clear to show that the intention of the applicant has already been made and failed. It is well settled that the procedure and law are for advancement of justice and not to thwart on technical grounds. Thus, in the larger interest of justice, the court deems it appropriate that the civil suit can be kept in abeyance. Thereafter, an appeal was filed to the High Court of Punjab and Haryana, which confirmed the same and held that the courts are meant to deliver substantial justice. The rules of procedure are handmaid of justice and are meant to advance the ends of justice, and they are not to be bogged down by the technicalities of procedure. And after this judgment of the Honorable High Court of Punjab and Haryana, the appeal was filed before the Supreme Court. So let us see what were the conflicting views of various high courts in our country. So let us first come to the judgment of Gangataro Vazirani versus Deepak Rakheja, which is a single judge bench decision of the Bombay High Court in the year 2021. So here the learned single judge took the view that Section 12A of the Act is a procedural provision. The court does not lack inherent jurisdiction to entertain a suit without complying with Section 12A of the Act. This judgment has been relied upon in both the impugned judgments which were challenged before the Hon'ble Supreme Court. Secondly, the division bench judgment in the case of Deepak Rakheja versus Gangataro Vazirani, which is the Bombay High Court judgment in appeal. Herein, the division bench held that Section 12A of the Commercial Courts Act is mandatory. There is no question of it being waived considering its object and purpose. Third, the judgment in Lakshmi Polyfab Pvt Limited versus Eden Realty Ventures Pvt Limited and another. This is a 2021 Calcutta High Court judgment which held that Section 12A of the Act is mandatory. Fourth, the judgment in Curevin Pharmaceuticals Pvt Limited versus Curevin Hylico Pharma Pvt Limited. This is a 2021 judgment of the Madhya Pradesh High Court which followed the judgment of the learned single judge in Gangataro Vazirani, holding that Section 12A is merely a procedural provision. Last, Avasthi Motors versus Managing Director measures Energy Electricals Vehicle and another, which is a 2021 Allahabad High Court judgment. Herein also it was held that Section 12A of the Act is mandatory. Now this controversy has been laid to rest in this judgment, wherein the Hon'ble Supreme Court held that Section 12A is not a procedural provision. Pre-Institution Mediation and Settlement has been declared to be mandatory, and any suit violating its mandate must be rejected under Order 7 Rule 11 of the Code of Civil Procedure 1908. Thereafter, the Honorable High Court of Delhi, in the case of Chandrakishore Chaurasia versus RA Perfumery Works Pvt Limited, comprising of the two-judge bench of Honorable Mr. Justice Vibhu Bhakru and Honorable Mr. Justice Amit Mahajan, on 27th of October 2022, held that compulsory mediation is foisted only on a plaintiff who does not contemplate urgent interim relief. It is only the plaintiff that can contemplate the relief that it seeks in a suit, and pre-institution mediation is necessary only in cases where a plaintiff does not contemplate urgent interim relief. So, as of today, the position is that a suit can be rejected if it does not comply with the requirements under Section 12A of the Commercial Courts Act under Order 7 Rule 11 of the Code of Civil Procedure 1908. However, this requirement can be dispensed with if an urgent interim relief is sought. I hope you have understood the judgment and the topic. Thank you so much for watching. See you next time.